Virginia, Mr. Goodlatte.
Thank you, Mr. Chairman. Inspector General Horowitz, your office discovered the practice of admitting known and suspected terrorists into the witness security program while doing a routine audit of the program and decided to issue an interim report on the issue. Is it common for you to find something so alarming that you need to issue an interim report to stop it?
Fortunately, it is not. We thought this was of such importance that we needed to issue the report and make sure steps were taken because the gaps were still there when we started this audit.
Thank you. And Assistant Director Harlow, specifically, why didn't the department share the new names and identities it provided known terrorists with the FBI's Terrorist Screening Center?
Mr. Chairman, the success of this program for many, many years was built on the compartmentalization of information, and as the program evolved, we failed to evolve our procedures and protocols. We have now changed those procedures and protocols, and we actively embrace them. It's also important to note that the FBI is the sponsoring agency in more than 80% of these types of cases.
So it was an intentional decision based upon a flawed protocol. Is that?
We recognized the problem with new leadership in May of 2010 and started to make those changes. Yes, sir.
And Deputy Assistant Attorney General O'Brien, the Department's response to the IG's report calls the participants in question former known and suspected terrorists. Can you tell us what a former terrorist is? Is there any guarantee that the participants have given up their bad ways when they join the program?
Mr. Chairman, I think it's important to note that these individuals, before they're admitted into the program, go through extensive vetting. That vetting includes a risk analysis by the sponsoring law enforcement agency. In approximately 80% of the former terrorists that were admitted into the program, they were admitted after a recommendation or sponsored by the FBI. These are individuals that turned on their organizations, and many of these individuals testified publicly against the organizations in which they were members of. So we go through very careful vetting before they're admitted to the program, which includes a risk assessment by the sponsoring law enforcement agency. And one thing we've done to ensure that there's no gaps in this risk analysis is that if it's a case in which an agency is sponsoring a witness into the program other than the FBI, we will ask the FBI to perform a risk assessment. Lastly,
I understand that some of them are still on the FBI's terrorist watch list. Is that another failure to share information, or is that because they disagree with your assessment of the individuals? What would be the reason for that?
Some of the individuals, not all, are still are watch listed. Some of them are watch listed, varying degrees of status on the watch list. I will say that the FBI, when we looked at this issue, when we began looking at this issue, the FBI performed risk assessments of these individuals. And as I said in my opening statement, currently the FBI has determined that there's no threat to public safety based on their program participation. That being said, Mr. Chairman, I think it's fair to say that we admit that the suitability and monitoring requirements historically employed by the program needed to be enhanced. One thing that we're doing now, which I think is very effective, is that we have quarterly meetings with the FBI and the Terrorist Screening Center, the Marshal Service, and the Department, and we go over the list of individuals that we've identified as being former known or suspected terrorists, and we share that information to make sure that we all have the requisite information that we need. And from the beginning, we've been talking to the FBI about having greater involvement with the FBI with this program, and the FBI has unfettered access to the files both of the Marshal Service and the Department. So that type of robust information sharing is now in place.
Let me ask you a couple more questions before my time expires. First of all, does the fact that two of these people in the program disappeared, and I now understand they've been located, but located outside the United States, does that call into question the soundness of the screening process, that they were no longer a risk as a terrorist and could be called a former terrorist? Or does it indicate that they cooperated in order to get away from everything and maybe back engaged in terrorist activities again? Do we know the answer to that?
Well, certainly, Mr. Chairman, we have no information to believe that these two individuals in which you've referenced have engaged in acts of terrorism.
Why did they leave unaccounted for?
One individual voluntarily chose to leave the program after being in the program for a short period of time. That individual left the program over 25 years ago. The second individual, it's my understanding, was terminated from the program when he no longer decided to cooperate.
All right. Thank you, Mr. Chairman. My time has expired.
Gentleman's time has expired. Gentleman from Michigan.